Good morning, everyone. I'm Kimberly Chalia with PHCA. Thanks so much for joining us for today's webinar. A few quick updates to share before we get started. This webinar is being recorded and will be made available on the PHCA website. The webinar has been approved for one continuing education credit for all attendees who are PHCA members. For those who provided a NAB number, credits will be uploaded within the next 2 to 3 weeks. As we begin today, all attendees should be in listen-only mode. Please feel free to submit your questions via the chat icon at the bottom of your screen, and we'll make sure to answer as many of those questions as possible at the end of today's presentation. I'll now turn it over to today's presenter, David Marshall.
Good morning, everybody, and hope you had a good time up at the Kalahari last week and now back at it at your offices. And unfortunately, we're here to talk again about some new changes from the Department of Health and some significant regulatory provisions that are going to go into effect in about 2 weeks here. So big picture, think about this as part of an overall trend at the federal and state governmental levels. And we're going to talk about those as we go through here. But one thing to note is that Pennsylvania here is actually a little bit ahead of the game and ahead of the federal curve on a lot of what we're going to talk about here. Now, it's really no secret that in the last couple of years, the industry has seen what I'll call an explosion of sales and transfers and mergers, and in the nonprofit world, affiliations of nursing homes. And there's a lot of reasons for that, and we don't necessarily need to get into those here today, but I put some of those on the slide. I mean, obviously, there's COVID and the occupancy issues. We've had ongoing reimbursement, certainly staffing issues that raise profitability concerns for facilities. There's a whole host of liability concerns in the wake of COVID. And, you know, there are defaults as a result of all of that under REIT leases and lending arrangements, the end result of which has been not just here in Pennsylvania, but across the country, a real explosion in sales and consolidation of the nursing home industry. So what we want to do today is for any of you out there who are either looking to buy or looking to sell, these regulations that we're going to talk about are, important required understanding in order to build into the concepts that you're going to talk about through a transaction. So a couple of real basics here, and we're not going to spend too much time on this because all of this presumes that you are going through a change of ownership. But it is important when you're doing this to understand what exactly is a CHOW, a change of ownership. And from a most basic perspective, I would say that if the tax identification number of the legal entity that holds the license is changing, then you've got a CHOW and you've got to go through that process. But there are differences at the Medicare, Medicaid, and state licensure level that are worth understanding real briefly. For example, at the Medicare and the Medicaid level at DHS here, if what you're doing is transferring stock ownership or membership interests in the licensee entity, but that licensee entity stays in place, that's not a CHOW for Medicare and Medicaid. However, it could be for DOH and state licensure, because under our state licensure scheme, if you're going to change any more than 5% of the ownership interest in a licensee, you've got to report that to DOH. And if you're going to move more than 50%, typically, in the interests in that provider entity, then DOH is going to call that a CHOW, even if Medicare and Medicaid won't. So that's some big picture structuring issue that if you're going to go through a sale, you need to always think about. But big picture issues too. Pennsylvania is a pre-authorization state when it comes to licensing. What that means is you can't sell the building without getting prior written approval from the Department of Health authorizing you to close the transaction. Now, Medicare and Medicaid are post-closing approvals that get issued retroactively to your closing date, and so is CLIA. But for purposes here, this is why these regulations are important, because you have to go through this process now and get a written approval from the Department of Health before you can close a transaction. So some source information for you here to reflect on and look at your leisure. And there's really two sets of regs in the new DOH regs that govern here. There's one reg that we're going to talk about briefly that actually went into effect February 1 of this year. And the bulk of which we are going to talk about goes into effect October 31 of 2023. So basically 2 weeks. Now, informally, in talking to DOH counsel, they would tell you that if you submit an application for a CHOW prior to October 31, that you would be governed under the current/old regs and not these new regs that we're talking about. With the caveat, though, that if your closing date is months and months away and you are simply doing this to get in under the old scheme, then the department will reserve the right to request everything under the new regs. So my gut opinion is that if you're going to close something by the end of this year of 2023, if you got your applications in by the end of this month, they probably would be governed under the old scheme and not this new one. So something to think about. Also listed here on the website, on the PowerPoint, is some guidance that DOH has issued that you can access through their website. So historically, for those of you who've ever gone through this process, I mean, the approval process with DOH was generally a 30-day period, and it didn't include an inspection of the facility, and it involved some, but I would call minimal review of the proposed new owners and their ability to operate the facility. And what's driving all this and what is coming out of the stuff that we talked about earlier are the following concerns from DOH, which they've expressed. I mean, if you go and look at the comments to the new regs and the preamble to it, they'll lay all this out for you. But, they have had a big problem in their mind over the last couple of years with private equity ownership and control of nursing homes, inexperienced operators coming into the Commonwealth, i.e. first-time nursing facility operators, complex ownership structures that, at least to DOH, are intended to hide individual ownership and control, financial instability of new owners, owners who get in over their heads and can't meet the debt covenants that they agree to when they come in to operate a building. And then finally, they have had issues, DOH would say, with new owners who come in there and significantly cut staff or services or other operational issues in order to, I guess, get a handle and control over what might otherwise be a spiraling nursing facility. But DOH has had issues with this. All of this is echoed by CMS, as we'll talk about. If you look at the CMS materials that have come out over the last year or so, they would say the same thing from a big picture national perspective. So that's the framework that we're dealing with. That's the framework that has driven these regs. So let's start talking about what the new regs require, assuming that you're definitely going through a CHOW. The regs have always required 30 days advance notice to the department of a pending CHOW, and that reg actually hasn't changed. What I would tell you is that you can say 30 days in advance, but under even the old system, you had to give DOH 30 days to actually review and process an application. So that 30-day notice requirement is something of a misnomer, and it's probably going to be more than that under the new system here. We'll talk about that. DOH is supposed to send you the updated applications once they receive your notice. Now, here's the one reg that has actually been in effect since February 1. The regulations now require a proposed new owner to notify the following folks contemporaneous with the filing of a licensure application, a CHOW app. You have to notify the state long-term ombudsman, you have to notify residents of the facility, and you have to notify employees of the facility. And as part of that notice, you have to give the name and address of the facility, the proposed new licensee. You have to give contact information for the ombudsman and a statement that the licensure app's been filed with DOH. And we'll talk about what they're going to do with that in a minute. So this has been in effect already. And what it requires are some important notifications. And what it has the effect of is requiring both the buyer and the seller to get their hands around this as quickly as possible so that the notifications can be made and can be made in an appropriate way that, doesn't scare off employees, doesn't alarm residents. If you're a unionized building, it fits within, what your collective bargaining agreement may require. The subtext, of course, to all of this is that the days of kind of I don't want to call it sneaking a CHOW through without giving a whole lot of notice to staff or to residents is gone. So what historically I think a lot of folks did and a lot of providers did for good reasons too, is unfortunately not the case anymore. So as part of any negotiation on a sale, you need to get your hands around this quickly and deal with it collectively as both parties to the transaction. So DOH has significantly increased the requirements for disclosure as part of the new regulatory scheme. And there are basically 5 categories that we're going to walk through of what's new and what has to be done. Disclosures for individuals, disclosures for entities, disclosures relating to related parties of both of those, operational and historic disclosures regarding the new ownership, and then financial disclosures for the new ownership. And those are the big broad categories of things that are going to have to now be reported as part of the CHOW process. So let's get into those and what they mean. And I will caveat all of this to say, we haven't gone through this yet. These regs don't go into effect until October 31. We will have to see how DOH approaches this. If you go back to some of the guidance that's been issued, there's fairly minimal guidance, interpretive guidance issued on these regs. I suspect that a lot of this is going to happen as we go through the process. But again, let's start here. For individuals, you have to provide the name, address, email address, and phone number for any of the following people now. Any individual who holds 5% or more direct or indirect ownership in a facility. So that's anybody who's got a direct ownership in the licensee or through a chain structure, through corporations going up a chain. That's indirect ownership. If that individual has more than 5%, as you apply that through the chain, they have to be reported. Any individual who holds any ownership percentage in a facility's real property or the building in where it's located. Any individual holding any interest in a mortgage, deed, trust, note, or any long-term liability that's secured by the facility's equipment, land, or building. And any individual holding any interest in the facility's management company or anybody who's an immediate family member of any of the above. Now, this is pretty significant, especially with respect to the property ownership and the management company ownership. Historically, you didn't have to report those folks. And I think a lot of investors used to take ownership interest in real property as a means of securing, their investments and not having to deal with operations of the facility all and the like. And at one point, you didn't have to disclose those folks, but now you do. So anybody who's going to hold any ownership interest in the management or the real property of the building is going to get reported. Any individual who holds 5% or more direct or indirect ownership in the licensee is going to be reported. And I'll caveat that to say that there are catch-all provisions in the regs that perhaps authorize DOH to request information on people holding less than 5%. Corporate entities. DOH now under the regs requires a complete picture of the ownership structure, both individually and at a corporate level of the licensee entity. So probably not too much for the folks here today, but if you're a nonprofit corporation and you own an interest in a licensee, then your officers and your board of directors, along with all their contact information and the nonprofit organization's charter and articles are going to have to be provided. If going up the chain of ownership, it's a partnership, then the partners have to be disclosed. Interestingly enough, the regs do not address LLC ownership, which is today the most common style of ownership, which is strange. But in conversations that we've had with DOH counsel, it's pretty clear that they're going to expect the members and the managers of an LLC to be disclosed. And this is the catch-all regulation in there. The regs require a disclosure of all, quote, shareholders in the licensee entity, regardless of ownership percentage, as well as the board of directors. And that term shareholder is not defined in the regs. And what is possible, I suppose, is that DOH would interpret that to encompass any individual who or entity that holds less than 5%. So we will have to wait and see how that goes with the department. But this is a significant expansion of the information that historically had to be reported as part of a CHOW. Let's keep going. Related parties. Again, DOH is looking for a complete picture of the facility, its ownership, and its operations. Now, by definition in the regs, a related party is a person, and I think as a practical matter, DOH is going to interpret the term person to be an actual individual as well as a corporate entity. But any person that provides a service, a facility, or a supply to a nursing home, or that's under common ownership or control with the nursing home is going to have to be reported. And by regulation, that means a home office, a management company, a real property owner, staffing, therapy, pharmacy, marketing, administrative or consulting companies, an insurance company, a financial advisor, banking, financial entities, or a holding parent or sister company. So again, this is a broad request to show everybody from an individual and corporate perspective who is related to the organization and the licensee. Again, this is something that was not in the prior regulatory scheme either. This is new. So for those who have multiple structures of ownership of facilities and who have ownership of various ancillary provider companies that service those facilities, the Department of Health is now going to ask for a big picture of that entire corporate system as part of the CHOW request. So what you can see hopefully here is that DOH is moving towards a full transparency of ownership with respect to nursing facilities. And again, we're going to talk about where CMS is heading as well. And I'm just going to pause here for a second before we get to the operational or the financial side of things that also has to be disclosed. But this is geared more towards operators and owners. I mean, you can see that DOH is seeking more information on the owners of operations, real property, and management than they ever did. My takeaway from this, and what I think operators have to think about, is that it's really, and if you're going to comply with the regs, it's really almost no longer possible to hide individual or corporate ownership of a nursing facility. Now, you may be able to, and I think you certainly can argue that if you as an individual own less than 5% directly or indirectly, that's not reportable, but we will have to see where DOH goes with that. But DOH and CMS are moving towards even more public disclosure of those individuals and entities holding ownership too, and we're going to talk about that. What I think it means for owners, operators, and investors is that I think individuals probably need to take a step back, and I think you need to understand what the expected disclosures are here. And those can be concerning for folks. I mean, there's a lot of people out there who really don't want their information put out there in the public eye. There's people who want to have, you know, what I would call passive investment interests in nursing facilities and other healthcare operations. And this is important to them. And as we've seen, you know, and as we will see, your name's going to get out there on various websites and things. So it's really not going to be possible to hide an individual ownership. And I would just simply say to folks that if you're considering getting into the nursing home game, or if this is an issue to you, then this is something you really need to talk about with counsel to determine exactly what you're going to have to disclose and where it would be and for how long and what it means. And this really, I think, is going to drive folks to decide and carefully weigh whether they want to get involved in the nursing facility industry, because this is the direction that both the state and the feds are going. CMS is a little bit lagging behind us right now in PA, but we'll see how this plays out. So that is kind of my first step back. This is what this is really going to mean here. for purposes of at least the CHOW process right now. We'll talk about that a little bit too. So things significantly for folks to consider. Let's move on to some of the other categories of disclosure here. So financial scrutiny. I said at the outset that DOH has concerns about providers coming in, taking over nursing homes, and then not being able to operate them, not being able to make them financially viable. And as a result, we're going to have to provide some of this following information now as part of the licensure process. First of all, the regulations require, one, audited financial statements of the proposed new licensee entity. It requires a visual representation of the ownership structure, including parent companies, shareholders, and related parties. In other words, they want an organizational chart that reflects everything that we just talked about of individual ownership, entity ownership, and related parties. So we're going to have to, as part of this process, put together probably some significantly detailed org charts for the new operators. And in addition to that, in addition to the audited financial, DOH wants a supplemental schedule of annual gross revenues of the licensee prepared in accordance with GAAP and broken out by payer type. So, all of that is, I think, fairly easily accomplished for an existing operating entity. But what do you do if the new licensee entity is a newly formed entity, which, as a practical matter, again, is the norm here? I mean, most folks, when they go in and buy a nursing facility, are going to go in and they're going to form a new legal entity, probably an LLC, with its own new ownership structure, and that's how they're going to isolate some liabilities and the like. So what do you do, though, because that licensee entity is a newly formed entity and it obviously doesn't have an audited financial? And the regs and the informal guidance that we've gotten from DOH to date aren't, I would say, terribly helpful. But what DOH counsel has said, in the absence of anything in the regs, is that the newly formed company must obtain and submit an audited financial report. DOH understands that there may be no cash flow or detailed expenses included in the financial report, but the report's required in order to demonstrate the financial solvency and ability of the potential licensee to operate a SNF. Well, that's quite the cost reporting and accounting challenge, to prepare an audited financial statement for an entity that's never operated before. But that's where we find ourselves for the moment anyways with DOH. My suspicion is that providers are going to be submitting various types of financial statements, perhaps not audited, financial pro formas and projections to DOH to see what they're willing to accept, as part of this process here. And as we go through the process, we're going to get more and more guidance out of DOH. But at the outset, it's not terribly clear. The other thing that's a little bit interesting about this is, and I certainly can't speak definitively on where DOH is with this, but my understanding has always been that DOH was going to have to go out and hire new staff to help address a lot of what we're talking about here, particularly the financial side of things. And whether DOH has folks within the regulatory department who can, appropriately evaluate an audited financial and a schedule of gross revenues. I'm not sure that they do yet. And as a result, I'm not sure how this is going to play out yet at the beginning stages of the effective date of these regs. That's unfortunately something we're going to have to see as we go through this. Now, more disclosures relating to the ownership and the history of that ownership, the proposed ownership. So some of this has always been required as part of the CHOW process. It hasn't always been in regulation, but it is pretty consistent with what DOH has done for the past at least 10 plus years. So, but now by regulation, as part of the application, the owners are going to have to provide a list of every nursing facility in any state or jurisdiction in which they have a direct or indirect interest of more than 5% in the ownership, management, and real property. You're going to have to list the name, address, phone, license number, and Medicare number for each of those facilities. Now, I will stop to say that the reg itself says that it is the quote licensee who has to provide this information. I think we all know, and we just talked about how the licensee here is likely to be a brand new organization, brand new company that has never operated before and so has none of this stuff. DOH is going to apply this standard to all of the individuals and the owners in that licensee that we've talked about. So there's probably not a regulatory legal argument that you could make successfully anyways to get out of having to report anything for any of the individual or entity owners in an applicant. So not only are you going to have to provide that list for all those facilities, but for all of those facilities on that list for the past 3 years, you're going to have to provide a list of all the surveys that they've gone through, including any citations, penalties, sanctions applicable to those facilities and the resolution thereof. That's not new. That's something that the Department of Health has been asking for the past at least 10 years, but it's now made it into regulation as a requirement. So that's DOH getting a handle on what you as a prospective owner own and what your history and track record is with respect to that ownership. DOH has also for years, for facilities that are owned and operated outside of Pennsylvania, has called their sister departments of health to get a handle on where that facility is and how it's treated and what the the history of that licensee operator is. So that's going to happen as well. Now, additional disclosures about individual and entity history here. DOH now by regulation will require a summary of all adjudicated or settled civil or criminal actions filed against the prospective licensee, which again, DOH is going to interpret to mean the individual owners and the entity owners. Now, to be clear, this is adjudicated or settled. That means if something is pending, it doesn't have to be reported. But if there is a settled civil case against the facility that an individual owner owns or against the individual themselves, that's going to have to be reported. So theoretically, and again, we have to go through this, we're talking about, wrongful death actions, for example, filed against an individual or a facility in which an individual owns. That's the type of stuff that's going to have to get reported now. So a very big expansion. This is absolutely new that's going into the CHOW process. And then similarly for those same individuals or entities, we have to provide a list of anybody who's experienced financial distress that's resulted in a bankruptcy, a receivership, an assignment or debt collection, restructuring, a foreclosure, a corporate integrity agreement with any federal or state entity, or the forced sale or closure of a nursing facility because of that financial distress. So, operating facilities that have gone through a bankruptcy, or a proposed owner who has him or herself gone through a bankruptcy or a restructuring or some kind of foreclosure of the business. Again, DOH is trying to get the big picture here of who is owning nursing facilities coming into the state here. So again, on the personal side of this, on the history side of this, DOH has greatly expanded what they're looking for and what they're going to be reviewing as they evaluate whether an entity or an individual is appropriate to come in here and operate a nursing facility in the Commonwealth. And then the last of those categories here that we talked about, the big picture, are operational disclosures. DOH not only wants to know whether the operator is appropriate and fit to operate a nursing facility, they also want to have a handle on what they're planning on doing once they get into the facility. So there are a number of things now that the new operator is going to have to provide as part of this process. First of all, a proposed staffing and hiring plan. Basically, you're going to have to show a plan that reflects the current staffing levels at the facility, along with vacancies, and then how you, as a prospective licensee, plan to meet the PPD requirements and ratios that are outlined in our staffing regs, including recruitment and retention plans. I mean, staffing is no surprise to anybody, the biggest issue out there across multiple disciplines and for multiple reasons. The Department of Health wants to know what the proposed new owner is going to do to ensure that the facility meets the staffing requirements. So that's number one. They're also going to request a staff training plan on what you're going to do to ensure that staff are fully competent on all the policies and procedures, particularly any new ones that you as a new owner might be putting into place, and what the schedule is. They're going to request a proposed emergency preparedness plan, which every operator should have and should be able to put together pretty quickly. They're going to request your proposed standard admission agreement, which is interesting because, as we all know, there's no actual regulatory requirement for you to have an admission agreement, even though everyone does. But now, in the absence of a regulatory mandate to have an agreement, they're going to require you to give them a copy of what you're going to use. So just as a aside and another practice tip, before you submit an admission agreement, especially if you're an out-of-state provider that's going to come in and impose a new agreement on there, you probably want to make sure that it's consistent with Pennsylvania requirements before you submit it. And then they're going to ask for a detailed budget for the next 3 years of operation, and showing, evidence of access to sufficient capital so that you can operate the building. In other words, DOH wants to be sure that when you come in here, you're not coming in underwater, or that you're not going to end up underwater within the first 3 years. And then they have to go through a process of having either another CHOW go through, or a temporary manager, or any of those things. So again, all of this is new from a regulatory perspective. The department has historically not asked for this stuff as part of the CHOW process, and certainly didn't factor it in as to whether a new operator is appropriate to come in. But here we are. So we have significant, as we've gone through individual entity management, history, financial, and operational disclosures that are going into the new CHOW process, which has greatly expanded what DOH has historically looked at as part of the CHOW process. So what does it mean from a timing perspective and from other avenues? I mean, until we go through that, we have no real idea how long it's going to take to process a CHOW application now. I mean, historically, I would tell you that you could pretty much get a CHOW application up and down and approved within 30 days, so long as you submitted accurately and completely what DOH has historically required, okay? And as long as you didn't have any issues as a new operator. It was normally a 30-day process. Now here, you do have, under the regs, a one-time 30-day opportunity to cure if they reject the application, but after that 30-day period, you're out, and it has to start all over again. So how long this is going to take, I don't know. If I'm going to bet, I'm going to bet because this is a new process, and I do not know how accurately staffed the department is to handle some of this stuff, especially the financial stuff. I'm going to bet that it might take up to 60 days at this point to get an application through to the department. That's a guess. We'll have to see. Now, we've talked a lot about DOH's desire for transparency here in ownership. And here's where this starts to come into play. And it also is part of the reason why I said earlier that if you're considering owning a nursing facility and you don't want your information put out there in the public, then you really need to take a hard think about all this stuff, because here's what DOH is going to do. They are going to post notice of receipt of the CHOW application on their website, and they are supposed to post, according to the regs, a copy of that application on the website and provide a 10-day comment period for anybody to comment on the application, okay? They're also going to post on their website whether your application was approved or denied. And again, we don't know exactly what this is going to look at. So in informal discussions with DOH counsel, they suggest that DOH is going to post the form portion of the application with no exhibits, And if you think about it, what I take out of that, if you know the applications, or if you've ever gone through a renewal, what I call the form portion of the application is simply the 2-page front and back application that lists the facility, its administrator, some basic information about the facility, and on the back there's a question about whether you're part of a pyramid ownership structure, and you got to notarize and sign. If that's all they post on the website, that probably won't include all of the real detailed ownership information about individuals, their EINs, their phone numbers, and the like. Just names and addresses of the corporate entity, probably. But we don't know that. We're going to have to wait and see. So that may or may not get posted on DOH's website. Now, you're not entitled to provide a response to any of these comments that get posted. And what weight DOH gives the comments is within their discretion. So again, go back to what I talked about at the very beginning at February 1. DOH, once they get an application, is going to post it online. So again, the idea that you can, keep a planned sale of a facility, hush, and just by word of mouth and only to those who need to know, that's not going to happen anymore. Now, we still have to wait and see what DOH is going to do with their website and see how they get that together. But that's what the regs require, and that's the plan here. Now, if you do get approved, then hopefully everyone will, with a lot more effort than historic. What happens just from a procedural matter is that DOH issues an approval letter, which then authorizes the parties to close the transaction. Now, over the last 2.5 to 3 years, these approval letters have almost inevitably come with conditions attached to them. And I would certainly tell anyone who is either a brand new provider to the Commonwealth, someone who is a current operator but has potentially some issues at other buildings, I would say that your approval letter is likely to come with some or all of these conditions. They're going to require you to submit a quality plan for how you're going to ensure quality at the facility. They are probably going to require you to retain an independent monitor for a period of time to assess the staffing and care at the facility. And that independent monitor is going to make regular reports to DOH. And you're going to be on the hook for the cost of that. It is likely to stay in place for a period of 3 to 6 months. And then once DOH is satisfied that everything is going, in an acceptable way, they'll release you from the monitor requirement. But that's likely to happen. There is now, under the regulatory scheme, and frankly, DOH would say there always has been, the possibility of survey of the facility. At this point, post-closing, more likely to assess, although DOH counsel would tell you that they reserve the right to have and schedule a survey prior to closing and prior to giving their approval if circumstances warrant. If you operate an ATSEP at the facility, DOH is going to request documentation regarding that and the approvals. And they're also going to require you to go out, as you should anyways, and rework the transfer agreements with local hospitals so that they are now in the new operator's name. So that is the big picture, and a very big picture, of what DOH is requiring effective October 31. One post note to this for everybody to consider. As of right now, the only component to this whole process that has been imported into the renewal application process is the requirement to submit the financial information. Moving forward, under the current regulatory scheme, you have to go through the licensure renewal process by submitting your app at least, I believe it's 21 days before the expiration date of your existing license. And now, as part of that renewal, you have to provide the financial information that we talked about here in these slides. To date, the remaining disclosures with respect to owners of the licensee, the real property, the manager, and the entities, and all of that stuff has not, at least by regulation, been enveloped or incorporated into the renewal process. All I would say about that is we're going to have to wait and see what DOH chooses to do. Because as of right now, again, all that we've talked about is applicable only in the context of a CHOW or a sale of a nursing home. Okay? That's DOH. Let's see what CMS is up to in the 20 minutes or so we have left, and I know we got some questions to get to. So in terms of process, there isn't a whole lot of change with CMS. I mean, CMS's regs have always required you to provide notice within 15 days of the CHOW. I think it's a practical matter through experience with not just CMS, but with the MACs. It's probably better to provide that notice at the same time you provide notice to DOH and DHS. When the MACs, send their, when DOH sends their packet of information for the applications, they do include some Medicare documents like the Medicare Provider Agreement, the 671 form, and some other things. And as always, the real document to effectuate a CHOW is the CMS form 855 that goes to the MAC, and there's a buyer's 855, and there's also a seller's as well. Now, that stuff hasn't really changed. But what started to change is last year with the White House announcing a set of reforms designed to improve nursing home care. And in February of last year, they said they're going to do the following things. They're going to create a database that will track and identify owners and operators across the states. They're going to enhance the Nursing Home Compare website. And to date, they've somewhat done that. If you've gone on it before, you can, by searching and going through certain databases, you can find ownership of facilities across states tracked by individual owners and entities. So they're working in that direction. They're going to tweak the Affordable Care Act, or pursuant to the Affordable Care Act, they're going to tweak their regs to require more transparency in corporate ownership, by collecting and publicly reporting more of this stuff. And there's an increasing focus on private equity ownership. I mean, the feds have the same concerns and problems with private equity and REIT ownership that Pennsylvania does. I mean, I think they're working hand in hand to doing that. Now, CMS is still implementing a lot of this stuff, but they're getting there. And what is important to know is that in February of this year, they issued a proposed rule which would change a lot of the reporting process for Medicare purposes with respect to CHOWs. And just in general when it comes to a nursing facility operation. So the proposed rule would require the reporting of every member of the governing body of the facility, name, title, period of service of each member, everybody who's an officer, director, partner, trustee, managing employee of the facility, including the name and period of service of each, everybody who's an additional disclosable party of the facility, and we'll get to that term in a second, and the organizational structure of those disclosable parties. I mean, the way that this would get reported, if you're familiar with the 855 form, is for an individual, they'd get reported in section 6 of it. If it's an entity, they'd go in section 5. What this will require, of course, is CMS to adjust these sections within the 855. Now, what's a disclosable party here for purposes of the proposed rule? Well, that would include any person or entity who exercises operational, financial, or managerial control, provides policies and procedures for use at the facility, provides financial or cash management services, leases or subleases the real property, provides management, administrative consulting services. And the rule also includes, private equity and REIT disclosure within there. So, I mean, again, a significant expansion. And I guess the difference here with Pennsylvania to understand is the way that this proposed rule is written, this wouldn't be exclusive to the CHOW process for Medicare. This would be anytime you have to update your 855. And remember, the 855 is required to be updated on material changes to the organization. And certainly then when you get through a revalidation stage, which is every 5 years, you have to report everything all over again. So the design of this rule is to capture ongoing a full picture of the facility and its ownership structure, and not just at a CHOW. That's a big difference from a CMS perspective. So again, I said that changes to the 855A are coming. In a Medicare Learn Network, a Medicare Learning Network fact sheet they put out, that CMS expected the changes to be ready for public use in summer of 2023. We're still waiting on that. We're still waiting on the finalization of the regs, but you can see where this is going from a CMS perspective. Now, another big change that happened, and this one actually has gone into effect and went into effect January 1 of 2023. CMS has added a criminal background check and fingerprint requirement to the 855 process that starts through a CHOW. And what the rule basically says is that anyone who's, as an individual, who's got a 5% or greater ownership interest in a provider or a supplier that falls into a high risk category for purposes of enrollment, which includes SNFs, has to go through this fingerprinting process as a condition of enrollment. And CMS has contracted with an entity called Accurate Biometrics to handle this. They're the only ones who can do it. You cannot go and get your fingerprints done at any other place other than an Accurate Biometrics location, or CMS and the MACs won't accept it. So how does this process work? Well, once the 855 gets submitted and you've disclosed all of your ownership here, the MAC is going to send a letter back if they're going to require fingerprints, and they're going to tell you who has to get their fingerprints done. And they're going to give you a tracking number for those fingerprints. And it's important, and it's absolutely critical to make sure that the contact information that you put in your 855 is accurate and is going to be monitored, because that's how Accurate Biometrics and the MAC are going to contact the people that need to be fingerprinted. And if these slip through the cracks, it's going to impact significantly on your Medicare approvals. So I put in here a phone number for Accurate Biometrics, and I'll have a website a little bit later here. But from a basic requirement perspective, these are supposed to be done within 45 days from the date of the letter that you get from the MAC. And we've talked about the accuracy of the 855A and what that means. But it's clear that any delays in this process are going to be delays in the ultimate CMS approval and assignment of the number. Okay. So be on the lookout for those as you go through a CHOW. And I put here the fingerprinting website. Just from a process perspective, CMS has cut out the regional offices from involvement in the CHOW and enrollment process. So here in Pennsylvania, Region 3 is really no longer the last step in that process. Now you're going to go through the MAC first, as you always do, and then the MAC will send its recommendations to what is called the Provider Enrollment Oversight Group, which is located within CMS itself, and to our State Department of Health. And then once the PEOG issues its approval, then the MAC will be in a position to issue the tie-in notes. So what this means from a process perspective is, and our experience since January of this year, is it's really going to take at least 3, if not up to 6 months following the filing of your 855 to get your tie-in notice to have the Medicare number absolutely assigned over to the new operator. That's how long it's going to take. And you should plan for that. And one of the ways you plan for that is in my bullet point here is through the transaction documents, is that you should make sure that the parties have worked out the new operator's ability to bill the Medicare program using the seller's NPI and the Medicare number, which is permitted by regulation. So that's something just as a side practical tip for you to deal with. On the DHS side, there's not a whole lot to report, but I wanted to just have a slide here for you. So, I mean, from a process perspective, there's not any real change. DHS still requires, this is for Medicaid purposes, DHS still requires 30 days advance written notice of a CHOW, and you got to, disclose the name, location, and the parties involved and a proposed effective date. The regulation actually does require you, as part of that notice, to specifically request the facility's continued participation in the MA program following the CHOW. Maybe seem like a small thing, but I would always have that in your notice letters. DHS has its own forms that all of the information has to be reported on, and generally speaking, they capture the same information that is required by CMS, and most of which is required by DOH. This is also a post-closing approval, like Medicare. They're both post-closing approvals. Once you get the approval once you get the tie-in notice out of Medicare, they'll issue the assignment retroactive to the closing date. Once you get DHS to approve the enrollment application, they'll issue you a new promise number retroactive to the closing date. And DHS's process is still normally a 30 to 45 day process. So that's a lot quicker than all the rest. So we have about 10 minutes here, and I know that I've whipped through a lot of this stuff because I wanted to get to it, and I know we have a couple of chats that I will look at in a second. But the big picture conclusions for all this to me are you as providers who are either selling or buying. I think we all need to expect that the regulatory CHOW process at both the state and the federal level is going to be more cumbersome than it has been in prior years. And especially here at DOH, and especially here at the beginning months as they navigate their way through this as well. I think, and it has always, in my mind, been incumbent upon buyers and sellers to build the regulatory timelines into their expectations for transactions. I mean, I think a lot of times, people want to hurry up, let's close. We want to get this done up and down in 30 days. And in the past, that may have been possible. I would be very concerned on whether we can do that now. And I think it requires parties to, really build in a timeline for doing these sales now, because there's more disclosure involved. There's more public disclosure involved that's required. And it's going to take some time to think about this stuff. And I think the final bullet point here is I would absolutely expect DOH to be issuing additional guidance, clarifications, and maybe even more regs as this process plays out over the coming months. You can always go on DOH's website, and they do post it through a link. You can find the reg, and it will have, usually in green or red, DOH's comments and interpretive guidance on what they interpret certain provisions to mean. But we're entering into a whole new world here. This is a significant change in this CHOW process here in Pennsylvania. I think it's probably fair to say that other states and the feds are going to be watching us, because we here in Pennsylvania are implementing a number of things that the feds are considering, and also that other states are doing. So with that, let me look in the chat here and see if we can have some questions here. Oh, it's just Kim's request for questions. So
it's my constant reminder, David. I like to submit those throughout the session just to make sure everyone knows where to submit their questions. I do see Carol. I see that you're asking about the slide deck. Yes, I will share that out when I send out the certificates for today's session. And if no one else has any additional questions that they want to share within the session, that's a-okay. Please feel free to reach out to myself and or David. We're happy to answer any questions outside of the session if they come to mind after we close out today. But I'm not seeing any additional questions. David, I really appreciate your time today. And let's give everyone back 7 minutes of their day.
All right.
Thanks so
An
much,
early
everyone.
lunch. Thank you all very much.